Tonight in Greater Boston, what these recent Supreme Court rulings mean for us here in Massachusetts. The federal constitutional right to abortion access is no more an issue for the states, according to the court. The same states that the same court declared cannot act on their own to put restrictions on who gets to carry a weapon in public. And separation of church and state became a lot less separate Friday and today when the justices backed a coach who publicly led his student athletes in prayer on game days. Planned Parenthood of Massachusetts President and CEO Dr. Jennifer Childs-Roshak, Stop Handgun Violence Co-Founder John Rosenthal, and ACLU of Massachusetts Legal Director Matt Siegel all join me ahead. It's a ruling we saw coming for weeks, but that didn't soften the blow of the Supreme Court's 6-3 decision to overturn Roe v. Wade for the 60% of Americans who support abortion access.
I'm angry, I'm fired up, the fight is not over.
Protesters have been on the streets outside the Supreme Court and across the country for days, including in Mississippi, where the Supreme Court case originated and is one of nearly a dozen states that now ban or severely limit abortion so far. And here in Massachusetts, where abortion is legal up to 24 weeks of pregnancy and later if necessary to protect the mother's life and health or because of a lethal fetal abnormality. State lawmakers are also looking at ways to expand abortion protection and access before they break for the summer. And immediately after the court's ruling came down, Governor Charlie Baker signed an executive order aiming to protect out-of-state patients and the abortion providers who help them from lawsuits. I'm joined by Dr. Jennifer Childs-Roshak, a physician and the president and CEO of the Planned Parenthood League of Massachusetts. So good to see you. Thanks for your time.
Absolutely. Thanks for having me on.
So the conventional wisdom is really bad news for women in much of America, but here in Massachusetts, they are protected. Is that your analysis so far?
Yes, that's correct. Here in Massachusetts, we have put into place a lot of protections that make a difference for women who live here in Massachusetts or can get to Massachusetts for care.
Let's stay in Massachusetts for a minute, and then we'll get to what the feds may or may not do on the good or bad side further than the Supreme Court. Is there more the state should be doing? I touched on it a second ago, but I should maybe put it, what should the state be doing to provide even greater protection for the women who are here?
Yeah, so I think, the governor's executive order was fantastic. The timing of that was really incredibly important and critical to providing care here in Massachusetts in this very uncertain environment. So I think, a very important next step would be codifying the elements of the executive order and potentially a couple other things as well to make sure that it's not just a temporary protection, but it's something that lasts throughout as long as we need it, into the future as well.
Regardless who the governor was. But let me just be clear about the Baker thing. I was right a minute ago, was I not, that it essentially protects in-state providers who provide some reproductive health care to a woman who comes here from out of state. Is that correct?
Correct.
And does it do anything else, or is that the extent of it?
Well, so it protects the patients as they come to Massachusetts. Mm-hmm. It protects providers on multiple levels. So extradition to another state, for example, like a Texas or state with a bounty law. And it also protects providers' licenses as well. So,
Doctor, one of the things that I never understand, even though I used to lobby and I use the term loosely on Beacon Hill, you say the next step is to codify this. I don't understand, and this is not your problem, why legislators think it's important to go home for 6 months when there's important business to do. I won't put that on you. But assuming they can stick around for an extra week, why can't they codify this right now before they go, again, on this multi-month vacation, theoretically to prepare for re-election? Why can't they do this now to assure the women from out of state who are contemplating come here that they'll have full protection?
Well, so I think they probably could do it either, now or within the next, handful of days. I think I would say the legislature has been extremely supportive. And the decision just happened on Friday. So while we knew that it was going to happen, I could certainly appreciate how folks were willing to do some proactive things in the legislature, but really wanted to see how things shook out. So I think there's time. And I think there's also been some very clear support that they've signaled already around things like the budget, et cetera.
So I hope there's that. I mean, there are a few $1 million they're putting in the budget, from what I understand. To do what exactly, Doctor?
So my understanding from the Senate side is that there's $2 million allocated in the budget to provide more funding for abortion funds for folks who need help affording abortion care, and then also for things connected to providing care, security, and some of the other patient access things that are really important.
Terrific. And again, that's not law yet, but it's in one chamber's budget, so hopefully it does become law. Can we go to D.C. for a minute? Former federal judge Nancy Gertner is going to be with me tomorrow night, and she has said repeatedly on the radio that while she not only believes there's statutory protection under the Roe Act that passed recently, but she believes that a case that her husband and she did years and years ago, he was the legal director for the ACLU of Massachusetts, provides constitutional protection for right to abortion. However, and there's a big however, she also believes if the Republicans take control of Congress, and there's a Republican president to sign whatever they do come 2025, that if they pass legislation saying that a fetus is a person, all the protections that exist statutorily and in the Constitution in Massachusetts would evaporate. Do you agree with that analysis?
Well, so I'm not a lawyer, and
okay.
I think if Judge Gertner says it, then I believe it to be true. She's certainly exceptionally smart and talented and experienced judge. I do think, though, one of the critical things that, and this is it's not the typical talking point for, I think, a healthcare person, but the Equal Rights Amendment is one way to make sure that there's a constitutional protection for women in America. And I think that's also something that that is probably worth exploring in a more deeper way.
I'm so glad you brought that up. Very briefly, for people who are watching and saying the Equal Rights Amendment, didn't that die? It would be in the Constitution if the archivist, an unelected official, decided that what some consider, anti-ERA people consider to be, quote, late state votes were not in fact late. It'd be embodied in the Constitution, and I'm so glad you brought it up. The protection you're talking about would be codified. Some are, maybe this is just putting hope ahead of reality. Both Senator Collins from Maine and Senator Manchin from West Virginia. Senator Collins, who at least says she's pro-choice, and Senator Manchin, who, while he says he is anti-choice, he believes that Roe was and should be the law of the land. Is there any pressure being put on by people like you and your national leaders to urge them to join other Democrats? Well, Collins is not a Democrat, but Manchin and Collins to join the majority of Democrats to carve out a provision in the filibuster that would allow the codification of Roe in federal legislation to happen? Is that being discussed?
Yeah, that's a great question. I would say yes is probably the short answer. I assume so, but I'm mostly focused here on Massachusetts. What I do know is that this is a horrendous decision that has come down with huge impact. And I think any angle, whether it's looking at the politicization of the Supreme Court, whether it's looking at justices and their ethics, whether it's looking at the Women's Health Protection Act, I think there are multiple ways to kind of get to the solution. And I think we need to do it that way. I think there's not one solution that fits all.
And one thing we could add to your list, I assume you'd agree, is for the FDA to decide that the pills for medication abortions could be over the counter, which would make life much easier for women who are getting the short end of things as a result of this ruling, correct?
Well, I think, any way we can reduce barriers to care. So whether it's emergency contraception over the counter, birth control over the counter, I think there are multiple ways to do that. And even just the current lifting of the requirement to prescribe medication, abortion medications, in a health center, like that alone, being able to mail across state lines, like those sorts of things are really critically important. And all of that can be done, under the support of a physician or provider as well, which also is really important for care.
Doctor, one last thing for you, a political question, is, the conventional wisdom to which I subscribe is people on the other side of issues like this and guns are far better at voting on that issue than people like you. I mean, generically, I don't mean you in particular. Do you see this as the motivator that most supporters of reproductive freedom suggest it could be come midterm elections?
I think it'll be a motivator. I mean, 51% of the population in the United States is female and can get pregnant, and at some point in their lives. And I think there's anything in America that impinges on individual freedom, I think does strike a chord. And we can talk about the Second Amendment, till we're blue in the face, but being able to decide when or whether to be a parent, having autonomy over your own body, being able to make your own healthcare decisions, that is liberty. And that is what I think will really strike a chord with folks. And I certainly hope, I think it'll get folks, my generation, your generation out to vote. I think it'll get the young people out to vote. So I do think we will see some significant impact.
And I really hope you're right, but the one cautionary note is a huge percentage of white women voted for a candidate in 2016 who said his litmus test for Supreme Court justices was that they be anti-choice, or as he called it, pro-life. So hopefully people, men, women, everybody is awakened to the reality. Doctor, I really appreciate your time. Lots of luck with your work. Thank you.
Thanks so much. Take care. Have a great night.
You too. Be sure to join us on Thursday at the Boston Public Library studio as Paris Alston, Callie Crossley, and Marjorie Egan host a community conversation about the abortion ruling, and you're invited. That's Thursday at 2, GBH Radio 89.7, and streaming online at YouTube/GBH News. Of course, just the day before the Supreme Court declared abortion was no longer a right in this country federally, they expanded another right, access to guns. In another 6-3 ruling Thursday, the justices struck down that New York law that said people needed to show a specific need in order to carry a concealed gun outside the home. And with that, the doors were thrown wide open for future lawsuits against the several other states that have similar common sense restrictions on gun ownership, like right here in Massachusetts. I'm joined by John Rosenthal, co-founder of Stop Handgun Violence and a longtime advocate for stronger gun safety measures. John, it's good to see you.
Thank you.
The conventional wisdom in anticipation of that Supreme Court decision, and even when it came down, was the Massachusetts law is so similar to the New York law that if the New York law is gone, Massachusetts will be next. But you and David Hogg from March for Our Lives wrote a piece in the Globe saying that they are different enough that we should not fear. Was that not putting hope ahead of reality, or no?
I think they are different enough. There's a big difference between, quote, proper cause, the reason why you're carrying a gun, versus being a suitable person to carry a gun. I know it sounds like words, but I think it's different enough. I also took some heart in Alito's opinion that, he is not undoing Heller or McDonald. And the Heller case in D.C., if you remember, Scalia wrote for the majority and said, you can't ban guns in the common use at the time of the founders. And he said, I don't mean semi-automatic weapons or assault weapons. They didn't exist. And like all rights, they are not unlimited, and you put reasonable restrictions on how guns are sold. So I think we're going to be okay, frankly. But I mean, remember, this is not your grandfather's court. These are conservative judges who seem more interested in changing culture than respecting laws, as far as I could tell.
Well, also, you're in part depending upon what Justice Alito said, but Margaret Marshall was on the radio with us, the woman who wrote the same-sex marriage decision 20 years ago, and said, and I'll be less polite than she was, don't believe him for a second. So the notion that he says that, I mean, the bottom line, without giving people a headache, is it seems to me at least, the issue with the Supreme Court was they don't want any discretion in the hands of local people like our police chiefs here. And even though you think the discretion in Massachusetts is narrower, it is discretion nevertheless, correct?
Oh, it's absolutely discretion. I mean, who knows their people better than local police chiefs? And so far, all of our laws have been upheld, have been challenged
Yeah.
and upheld. I mean, but, the future is uncertain when you've got activist judges who, again, don't seem to really respect the past and are trying to, make rules up as they go.
Well, I want to quote you to you in that same op-ed. You say near the end, but will the Supreme Court end there? Where are areas, what are directions in the gun world and the gun owners' rights world that worry you most that they may go down next?
It's a good question. I mean, clearly the gun lobby has a take no prisoners approach. They think that even a background check is an imposition on gun owners' rights. That's not what the Supreme Court has said in the past. But remember, you can't even get 60 senators to support a background check where you need a background check to drive a school bus. I mean, you need an ID to get a Claritin, but not to buy 1,000 weapons a day in 32 states from private dealers. I mean, it's anybody's guess. But I do know that urban Massachusetts has the most effective gun laws. We've reduced the rate of gun deaths by 40%. And if every single state had simply the low gun death rate and treated guns like cars like Massachusetts, 27,000 lives could be saved a year without any inconvenience to law-abiding gun owners. So, if the goal were to actually protect people with good, strong gun safety laws without infringing on the Second Amendment, look no further than Massachusetts. Unfortunately, I think this Supreme Court, may go further. We just don't know to what extent. And, right now we know the Republicans are owned. I shudder to think that the Supreme Court, a majority on the Supreme Court, is owned as well.
Is there room? I mean, we should say you're being a little modest. You're in part responsible for the fact that we do have those kind of tough laws and that we have the reduced incidence of fatalities and those sort of things in our state, meaning the laws do work despite what some of the opponents say. Is there even more that our legislature could do that you're fairly confident would avoid the wrath of the Supreme Court?
Well, good question, Jim. I know that our legislature right now is consulting lawyers to make sure that our existing laws can withstand a challenge. And if we have to tweak those laws, I think we will. And we've passed our gun laws with bipartisan support. And I know we have the support of the governor, and I know we have the support of the attorney general to support the legislature in protecting these gun laws. I mean, they do save lives, but Jim, I mean, you can only save so many lives when, anyone can still go to Maine, New Hampshire, Vermont, and 32 states in total and buy an unlimited number of guns and bring them into Massachusetts. So, we're up against it. And the Supreme Court is not helping save lives in America from preventable gun violence.
By the way, I think some people have heard the story, but you took my radio co-host colleague to New Hampshire to a gun show a number of years ago to prove that point. And she asked about a high-capacity magazine, and the guy was ready to sell it to her. And she said, but it's not legal in Massachusetts. And his response was something like, well, nobody needs to know, do they? Wasn't that essentially what she heard?
That is exactly right. And Jim, I mean, Marjorie and I also saw, some young teenage kid walk out with a grenade launcher attachment to an AR-15 cash and carry. I mean, this is America. This is truth is stranger than fiction when it comes to gun policy. And it's the reason why we have more gun violence in America than 27 industrialized nations combined. It is by choice. And it is like the Supreme Court choosing to take, to respect unlimited access to guns, but at the same time, take away a woman's right to choose. This is not the America that we all thought we were living in, and we better wake up. America is calling. We have got to get out and vote these conservatives out of office and ultimately change the court, or we are going to lose our democracy. And seeing reproductive rights and seeing gun rights trump, healthcare is insane in America.
On that note, John Rosenthal, thanks for your work as always. Talk to you soon.
Thanks for having me.
Tomorrow, the Massachusetts Coalition to Prevent Gun Violence will be hosting a screening at the Boston Public Library of the Emmy-nominated documentary film This Ain't Normal, which focuses on gang violence in Boston neighborhoods and the organizations trying to get these young men off the streets.
This is not an accident. All of these homicides are happening within a 3-mile radius. If you think you can make me believe that Boston, Massachusetts, one of the best forensic systems, law enforcement systems in the world, can't control 3 miles, you're crazy as all out hell.
There was a shooting, there was a murder, a shooting, but nobody said anything about that. So that right there tells you what society's vision and view on what's going on in the inner city don't matter.
Why do we all need the care? Because the issue of murder, the issue of violence, the issue of death by a gun is happening in urban, suburban, and rural communities throughout America. We need to rally about this.
It's a really important film. For more information or to register for the screening, visit bpl.org. And in yet another 6-3 decision today, once again along ideological lines, the Supreme Court ruled in favor of a Washington State public high school football coach who was fired by his district for leading prayers at the 50-yard line after games. In the majority opinion, Justice Gorsuch ruled the firing was unconstitutional because both the free exercise and free speech clauses of the First Amendment protect expressions like this. This is just one of a number of recent rulings that appear to weaken longstanding legal precedent for the separation of church and state. Just last week, the court ruled a taxpayer-funded private school tuition program in Maine cannot exclude religious schools, just the latest in this trend of allowing greater and greater state involvement in religion. I'm joined by the legal director of the ACLU of Massachusetts, Matthew Siegel. Matt, it's good to see you. Thanks for being here.
Thank you, Jim.
You know, starting with this main thing, we're talking about what impact these decisions have in Massachusetts. Weren't we one of the 37 states that had a constitutional prohibition on public aid, meaning taxpayer funding, for schools to go to religious schools? Am I not right about that?
Well, we do have in Massachusetts something called an anti-aid amendment. Right. But one of the things that I think is important to understand about the Maine case, but also the football prayer case, is that the facts of the cases that the Supreme Court decided might be substantially different from the facts that exist in Massachusetts.
How so?
So even though there was this program in Maine which was a tuition program based on the idea where private individuals are given assistance to attend private K through 12 schools, but so long as they weren't religious. Massachusetts is a little different. We don't have a program precisely like that. And nor do we have within such a program a law that singles out religious private education. So we're not handing, to my knowledge, we're generally not handing parents money to say you can use this money on a private school so long as it's not religious. And for that reason, it's not obvious that the pronouncements by the Supreme Court, as worrisome as they may be on a broad scale, are going to have an immediate impact in Massachusetts.
Well, that's somewhat comforting. Do you feel the same way about this kneeling at the 50-yard line? I have to say I'm a big fan of NPR because I work for a local outlet. But when I heard NPR reporting on this decision this morning, they said, the coach invited players who wanted to pray with him. And when you're the head coach, who happens to be taxpayer funded, and you say, I'm going to pray, but you don't have to, that to me sounds like I would suggest you get here if you want to start in the game on Tuesday. Is that of limited concern to you too?
Well, I have a similar response. First of all, as a civil rights lawyer, but also as a parent, I have some doubts about the facts as they were characterized by the Supreme Court. I mean, my kids play sports. We all understand, and I think student athletes implicitly understand, that the optional stuff isn't truly optional. But what's important for purposes of understanding what the Supreme Court did to the law this morning is that the facts as articulated by the majority in the opinion are the facts that will determine what their legal pronouncements mean. So when they say, as they did in this opinion, there was no evidence of coercion, that means that people will be free in future cases to get a different result when they can establish that there was coercion. Now, in the dissent in this case certainly says, wait a second, those aren't the facts. The actual facts here are that there was evidence of coercion. But as construed by the majority, there's no evidence of coercion in this case. And so, like my answer to you, Jim, with respect to the main case, this might be another case that is not necessarily going to have a broad impact in say, Massachusetts, when there are situations where the coercion is obvious.
Yeah, but by the way, I'm comforted by this after the nightmare of virtually every other ruling. And I know you have deep concerns beyond our borders, but to I was going to say a layperson, I'm theoretically a lawyer, but not like your kind of lawyer. Isn't there de facto coercion when an authority figure like that says, feel free not to participate? I mean, I'll tell you, if I was on that team, I wouldn't feel free not to participate. Am I barking up the wrong tree?
Well, certainly what you're saying, Jim, is in line with what the dissent said. And I'm not here to tell you or any listener or viewer that everything's just fine and dandy at the Supreme Court. That is not what I'm saying. It's rough. And I'm not here to pretend either that this decision will have no impact on eroding or chipping away even significantly at the wall between separation between church and state. But what I am here to say is that if you're a parent out there, a student out there who really is being coerced, this decision does not tell you to just stay silent and not tell you to seek help. You can go and get help, and you should contact people.
And I only have 30 seconds left, but I know this is Nostradamus time. But based upon everything from Hobby Lobby on down, this is the direction that religion, I was going to say, and guns, frankly, but religion trumps all with this court. Is that not a fair statement?
Well, one way to think about it is if the Supreme Court of the United States were an administrative body and its decisions were to come up for review before the Supreme Court of the United States, the Supreme Court might say that those decisions were not fair.
On that note, Matt Siegel, it's good to see you. Thanks so much for your thoughts. I really appreciate it.
Thank you, Jim.
That's it for tonight. Please come back tomorrow. Constitutional scholar, Harvard's Lawrence Tribe, and former federal judge Nancy Gertner, both members of President Biden's Supreme Court Commission. They'll join me with more on the broader implications of these landmark decisions, the future of the court itself, and their analysis on the January 6th hearing that was just added for tomorrow. That hearing starts at 1 o'clock, and a reminder, you can listen live on GBH Radio 89.7, along with Marjorie Egan and me. You can also stream the hearings live at gbhnews.org or catch them live on the GBH World Channel, which is offering a full re-airing at 3 a.m. the morning after each hearing as well. That and more tomorrow at 7. Thanks for watching, and please don't forget Ukraine.
The ruling is in.
The U.S. Supreme Court has overturned the constitutional right to an abortion.
Now, let's talk about it.
What does this mean for abortion rights in Massachusetts?
We're hosting a community conversation.
Join us Thursday starting at 2